Chat disable.
Good morning, everyone. It's my absolute pleasure to warmly welcome you all to this specialized webinar on overview of General Data Protection Regulations Principles organized by CZ Private Limited. So we are honored to have such an enthusiastic and diverse audience joining us online. Before we proceed, I would like to make you aware on general housekeeping practices and few announcements to make smooth running of this online webinar. We kindly request all the participants to mute their microphones. We will give you the opportunity to clarify your questions at the Q&A session. If you have any clarifications, please type in the Zoom chat box and we can discuss those questions during the Q&A session. To maintain clarity and professionalism during our online session, kindly update your display name as personal name with the organization that you represent. Now you can follow the example which now appeared in the Zoom chat box. During this online session, if you encounter any technical challenges or require any assistance, please do not hesitate to contact us. We will provide you the support. Look for our contact details displayed in the Zoom chat box. Your smooth participation is our priority and we appreciate your cooperation in ensuring a seamless learning experience. We are pleased to announce that e-certificates of the participations will be awarded to those who submit their feedback form, which will be found in the Zoom chat box before ending the session. Your feedback is mostly important for us to continue delivering high-value programs organized by CZ Private Limited. Now let's move on to the next segment that I am pleased to share insights on CZ Private Limited for your host for today's event. Let me begin by introducing CZ Private Limited, a leading certification body in Sri Lanka. We are proud to be recognized as a trusted partner in delivering internationally accredited certification services. At CZ, we value reliability. Our clients can trust us to deliver consistent, high-quality certification services that meet international standards. We also provide efficient and cost-effective solutions tailoring our services to fit your organization's need and making international certification more accessible without unnecessary expenses. At CSET, we are dedicated to provide a comprehensive range of internationally recognized certification services. Under ISO 17021, it covers system certifications helping organizations to certify their management systems like information security management systems, food safety management systems, quality management systems, environmental management systems, occupation health and safety management systems, energy management systems, education organization management systems, business continuity management systems, privacy information management systems, hazard analysis and critical control points. Under ISO 17065, it covers product certifications like SL Organic, GMP for cosmetics, and GMP. In addition to that, CSET offers certifications for GHG, validation, and verification. Let me walk you through our certification process at CSET. The process begins when we receive an inquiry from a client. Then we send the application form, and once we receive the filled application form, we prepare and share a tailored quotation or proposal. After the proposal is accepted, we conduct an adequacy audit to review the client's documentation and ensure it meets the relevant standard requirements. Once the adequacy audit is completed, we proceed to the on-site initial audit, which consists of two stages. The first one is stage 1 and the second one is stage 2. After the stage 2, an independent certification committee reviews the audit findings according to their decision and the certification is issued. For system certifications, the certificate is valid for 3 years with annual surveillance audits to ensure continued compliance. For product certifications, the certificate is valid for 1 year. At the end of each cycle, 3 years from system certifications and 1 year from the product certifications, a recertification audit is required to renew the certification. Following the recertification audit, the findings are reviewed by our independent certification committee. Once approved, the certification is renewed 3 years for system certification and 1 year for product certifications, allowing clients to maintain continuous certification with CSET. Now we would like to announce our upcoming training programs designed to enhance industry knowledge and support compliance with international standards. We will be conducting a 2-day physical training session on internal auditor training for food safety management systems scheduled for 23rd and 24th of April this year. So these sessions are ideal for professionals looking to upgrade their skills, ensure compliance, and stay aligned with evolving international standards. Contact us today and secure your certification through our trusted partnership and engage with our social media pages to take the first step towards ensuring your organization's future resilience and success. Let's embark this journey together. And thank you. Now it's my honor to introduce our distinguished resource person for today. He is a senior IT service management and information security consultant with over 33 years of professional experience, including nearly 30 years in the IT industry across diverse sectors. He is a certified lead auditor for ISO IEC 27001, ISO IEC 27701, and ISO 9001, and several other ISO standards. He currently works as a freelance trainer and consultant, supporting organizations in ITSM, information security, and service excellence. Without further delay, let's dive into the hearts of today's session. Please join me in extending warm welcome to Mr. Muktesh Murthy. Over to you, sir.
Thank you, Dharni, and welcome all of you. You can hear me, right? Can all of you hear me?
Yes, sir. We can hear you.
Okay.
Yeah.
All right. So, good morning, all of you, and welcome from Hyderabad, India. So, I'll be taking the next an hour and a half to give you a small overview of the most popular data privacy regulations called GDPR. And please understand, this is I generally take it as a 2-day course, but I've been asked to do it in 2 hours. So I'll be rushing this through. I'll only give you an overview of what this looks like. And as we move forward, I think you may have any questions. Please feel free to write in the chat. And we will be trying to cover this. I was fortunate enough to do an implementation of GDPR in UK in the year 2018. That's the time it came out. So I have hands-on experience in GDPR, and I've also been training people on GDPR and a few other standards. So I'm also certified for the latest standard for ISO from ISO called ISO IC 27701 2025. So the latest version is the 25 version. The earlier version was 2019. But having said that, let's start off with what is generally considered to be the mother of all standards for data privacy, which is called GDPR. And before we go there, this is the first place where it actually came out from. So according to Article 4 of GDPR, anything which is done with respect to collection, use, or destruction is called processing. So please make this very, very clear from your side. Any personal data that you're collecting, you're using, or destroying, any of these areas comes under the scope of data processing. Now, this can come out to be something very different for you. You've been, all of you have heard that any data, unless it changes, the state of data changes, only then it comes under GDPR. But unfortunately or fortunately, GDPR regulatory body came up and said anything where you're even obtaining, recording, accessing, storing, holding, receiving, tracking, I send data to you, you are under the GDPR scope. You're using it, you're altering, you're sharing, including destroying or anonymizing or shredding. The entire life cycle from the time it is created to the time it gets destroyed, that entire life cycle comes under the processing of data. Personal data. So what is personal data? Personal data is anything which can personally identify who you are, which is, and it has to be a living person, please. So unlike any of the other places, this is only meant for people who are presently living. In certain cases, if you have to process data of someone who has been deceased, maybe for hospital purposes or for medical purposes, that could be different. But then generally speaking, processing of personal data where you have got your name, address, phone number, etc., is all called as personal data, which is also called PII as per privacy data. PII means personally identifiable information. And anything which is sensitive in nature, which you do not want to share with others, is called sensitive data. I'm going to talk about this a little later in the game. There is a separate article only for sensitive data. So anything which is sensitive in nature in terms of racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union, genetic data, biometric data, your data concerning health. A lot of you are also working in health areas or in the areas of pharma or anything to do with sexual orientation. Any of these which are very sensitive, which you do not want others to know, comes under the gamut of sensitive data as per GDPR, a personal sensitive information, SPII, under the privacy management system. So let's directly jump on to what GDPR is, and it had a bit of a history. It was a directive, which means that it was a guide earlier. It was based on the directives that each country's parliament had to pass. Countries outside EU, such as Canada, Argentina, Australia, and New Zealand, passed their own Data Protection Act. The regulation, the Union Parliament passed it in the year 2020. And since 2020, 28, since the year 2018, it has come into play. But the history is, in 1950, it was called the Right of Privacy. In 1980, OECD, which is the Organization for Economic Cooperation and Development, which had countries like Canada, Argentina, Australia, New Zealand, they decided to create a directive about data privacy in 1980. 1995 EU, that is the European Union, consisting of 28 countries at that point in time, which included UK. UK came out in the year 2020, so it is now only 27 countries. And UK decided to release their own standard in 2018 called the Data Protection Act. So in 1995, EU passed the European Data Protection Directive that each country in EU has to pass its own act. GDPR came into force in April 2016. On the 25th of April 2016, it came into force. That means the regulation body passed it as a regulation. They gave 2 years and they asked people to comply within 2 years period. Just like now in Sri Lanka, you have the PDPA, which is still under regulation. Only a couple of acts have come into play. Similarly, in India, there is something called DPDA, which is called the Digital Privacy Act, Data Act, which is again come into force. And by 2027, it's going to be applied here. Globally, there are close to 160 plus countries which have already got the local privacy acts in place. So in 2016, the European Parliament in April passed a regulation giving you time till May 25th, 2018. That was when I was in UK releasing this at that point in time in UK. So the regulation came into effect on 25th May 2018 and became applicable to 27 countries across Europe. The territorial scope was extended to 30 countries, which means today GDPR is applicable to 27 countries in Europe and 3 countries, which is Iceland, Liechtenstein, and Norway. So there are 30 countries, which is also called the EEA, European Economic Area. So EU plus the 3 countries is where GDPR is today applicable for, and this is something that we will look for. And there is this concept called adequacy provision, which I will cover a little later in the game today. Adequacy provision is in case you want to transfer data between the EU and any other country. European Union has called out certain countries where they say that you have adequate safety guards put in place in that country for me to transfer data. First thing is that you can transfer it to any of the 30 countries. There should be no problem. In case you want to go outside the 30 countries, now I am in Spain and I want to send data to, say, France, you can automatically do that. But if I'm in Spain and I want to send it to, say, India, does India come under the gamut? You'll have to see. What it does is it says 30 countries, which is the 27 countries in Europe, plus Iceland, Liechtenstein, and Norway. Anything outside that, they have put another bucket called the adequacy provision, which means companies from Andorra, Argentina, Canada, Faroe Islands, Guernsey, Israel, and all these countries, New Jersey and New Zealand, etc., are the only other countries, and this keeps changing, guys. So if you search for adequacy provision of data, you'll get to see the latest data. So EU is of the opinion that these countries have set up certain safeguards which allows us to send data to these guys. Which means tomorrow outside Europe, if I want to send data to New Zealand or Switzerland or Uruguay or Andorra or Argentina, I should be able to do so. Any other countries, there are additional safeguards that need to come into play, which is going to be discussed a little later in the game. So adequacy provision is a concept which allows European Union countries to send data to other countries which have got adequacy provision. Now, what is GDPR all about? There are 99 articles and there are 170 recitals which are supporting context. GDPR came into full effect on 25th of May 2018 after it was approved in April 2016, replacing the older protection laws. What you need to understand here, guys, is that it was called a directive earlier. The only problem with directive was that as a directive, it was only a good to have, it was a guide, and people still did not follow the guide. So there was a huge amount of uproar, a huge amount of noise in the European area. So people felt that the data was being misused. And I'm sure all of you are also seeing this happening on a lot of places. You see that your data gets misused when you put it up in a social media and your name, address, phone number goes into places where it should not go to. So European Union came and said, now that I put a regulation, there'll be penalties put in place. And these penalties have reached close to around $7 billion since 2018. And I'll show you that sheet a little later, that the 2018 directive has now resulted in penalties worth almost $6 billion. So it is automatically binding. And there is this link called gdprinfo.eu, which I will cover a little later, where this is something that you should bookmark. If you are part of the GDPR Alliance at any point in time, all those 99 articles that you will see are all in this particular site. So if you can go to this site, this is the site where all the 99 articles are mentioned, and you can expand them and you can start reading them out whenever you feel like. And these are 99 articles that you can pick up. Any activity or any line item you want to read, you can read them, and then there are recitals at the end of each and every item. And you can read them through, and then you can take it from here. And you can see these are called the recitals. Recitals are additional supporting text for GDPR. So what GDPR does is, GDPR has said that I will give you 99 articles, which you will need to read. And not all 99 articles are mandatory for you. If you are part of Europe, then these 99 articles may be applicable for you. But if you are part of any other country outside the EU, only a few of them will be applicable to you. and we will cover that as we move forward. To stop me whenever you have any issues. So GDPR has a total of 11 chapters, and sub-chapters have sections, and we will cover the penalties that we are looking at. This is the most important piece that you need to look at. Some of the penalties are 20 million or 4% of the revenue. Whichever is higher, this is something that you will have a look at as you move forward. So the penalties have been very high. And today there are close to around 100 and there are some chapter, and I will show this to you. You'll be amazed at the amount of penalties that people have come to. And there is a site called the GDPR Enforcement Tracker. Now, if you go to this tracker, you will notice that there are fines and statistics as of today. And this fine database, if you notice, it started in July 2018, starting with $400,000. And today, as of last month, it's standing at $6.8 billion. Euro. There are 2,781 infractions that have happened in the GDPR space. This is a total overall cumulative, and this is month by month. The highest was in the year 2024, where in one particular month, there was over $1 billion worth of penalties that took place. And this happened sometime in May 2023, $1.2 billion only in 1 month. Last month was only some $500,000. There are 47 million, and it keeps moving forward. And this site also tells you what are the different sectors. So you have countries like Ireland. Facebook Ireland has been one of the largest penalty grossers, close to $4 billion out of $6.8 billion. And types of violations, which you'll anyway cover, and the sectors, media, telecom. And in terms of companies, you can see Meta, in 1 year, they have done $1.2 billion. And then you've got Amazon, you've got TikTok, Meta again. In the top 10, Meta has come at least 5 times. So Meta has always, and especially Ireland, Meta has always been a challenge. And I'll strongly suggest that when you're working in your social media channels, there's a lot of chances that your data that you're keeping in any of these social media channels will get used or misused. So it is your responsibility to ensure that your data does not get misused by these social media channels. So having said that, what you need to understand is that the structure of GDPR, there are 11 chapters. First chapter is from Article 1 to 4. So you have 4 articles under this, which is called general provisions. Then you have principles, which we will cover. There are 7 principles of data processing, which is Article 5 to 11. Then you have rights of the data subject. This is again very important one that you need to look at. There are Articles 12 to 23, which we will cover as we move forward. So as a data subject, what are the rights that the GDPR has come up with? And this is the foundation of all the other standards that has come up post that. Then there is a very large sector on controller and processors. And what does a controller do? What does a processor do? From Article 24 to 43, there's a lot of discussion on the articles of the controller and processor. Chapter 5 is something that we as organizations have to follow. This is with respect to transfer of data. Article 44 to 50 is all about transferring of data. So how do you transfer data between you and the third countries? Now, we discussed this a little earlier where we said that the transfer happens automatically between the EU countries and also within the adequacy provision countries like Argentina and Switzerland, etc. Now, if you have to transfer data outside that, what could be the concept will be covered as part of Article 44 to 50. Then you have an organization or a body called the supervisory body. And this is a government body which is expected to run and manage it's a governance body which is meant to govern your data privacy actions. So any data breaches that you have to report it to these guys. So it is very important for you to understand that these are government-run bodies. Even PDPA is being run and it is being governed by a Sri Lanka board. So these are called supervisory authorities. In India, it is called the Privacy Board. In other places, it's called the Privacy Commission. So each country has its own nomenclature of what it is called. So what are the powers of the Independent Supervisory Authority? Comes from Article 51 to 59. How do they talk about cooperation and consistency among the supervisory authority? Will be covered in Article 7. Article 8 is again something that you have to be careful of is with respect to penalties. So GDPR has come back and given you penalties that are taking place. So there are 7 to 8 sections or articles under the penalty clauses. So we will read that, we will see that during the course of the journey. And then there are, how do you work on a particular provision, which is again something that will not be applicable to you. But in the Europe board, if you are part of the European organization, how do you work on special conditions? How do you work for the church? How do you work for other bodies in Europe? Will be covered as part of Chapter 9. Chapter 10, there are some delegated activities that GDPR allows people to delegate. And then there's are provisions. So there are 11 chapters that GDPR comes up with. But for people who want to lead and read GDPR, especially from the implementation point of view, articles, chapters 1, 2, 3, 4, 5, and 8 are important. All the others are good to know. But these are the only chapters that you will be mostly working with. And all the others is just something that is academic in nature for you. So let us quickly start off with some of the definitions of the articles. So the first one is the scope of GDPR. Now, for people who are aware of what GDPR is, now that you know what GDPR is, whom does it touch? The regulation applies to the processing of personal data. And what is the processing? Any of these activities that you do. Any of these activities you do is called processing. So whether I'm obtaining, I'm recording, I'm accessing, any of these activities, if you do as part of GDPR, you will come under the scope. And what does it mean? It means that the regulation applies to the processing of personal data in the context of activities of an establishment or a controller or a processor in the union. So for you, if you are a controller or a processor, I'm sure I did this in the last seminar. A controller is someone who decides what needs to be done. So it's Article 4. So as per Article 4, anything that who decides what is done to a data is called a controller. For example, you go to a bank, you are the data subject. You go to a bank and you give your data to a bank, he is called a controller. And he decides what needs to be done. Now the controller decides to give the data to a software department to process some reports. So he becomes a processor on behalf of the controller. So in that aspect, what happens is if I create a controller or a processor in the union, that comes under the scope. I have a company which I've opened in any of the 27 countries in the EU. I automatically come under the scope of that particular processing. I've got a branch. I open an account there in EU. I become part of the scope. Second, this regulation applies to the processing of personal data of data subjects who are in the union. Right? So you can see the second part says the regulation applies to the processing of personal data of data subjects who are in the union by a controller or processor not established in the union. So I have a data subject, everyone knows, is someone whose data you're collecting, personal data. So I have someone in Europe, I am collecting data for someone in France, but I am not in France. I am sitting outside in Sri Lanka, I'm sitting in India, I'm sitting in Dubai. You are still under the scope because you are processing data of a European citizen or a European data subject. In the first place, the company is in Europe. In the second place, the data subject is in Europe, whereas you may be outside. So the regulation applies to the processing of personal data of data subjects who are in the union by a controller or processor not established in the union, where the processing is related to offering of goods or services, irrespective of whether the payment of the data subject is required or monitoring of the behavior. So this is called, these are the two scopes that you're looking at, guys. And the third one, this regulation applies to the processing of personal data by a controller not established in the union, but in a place where the member state law applies by the virtue of public international law. So if your company is in the union, you will be under this scope. If your data subject is in the union, then you come under the scope. If the law applies, there's a public international law where your data needs to be processed outside. Say there's a criminal law, you are running out of, you're a fugitive, you're in the FBI, or you're under the European criminal law, your data is, you're traveling outside, your data can still be processed and you will come under GDPR. So this is a little confusing, guys, for you. You may need to revisit this again. But to answer your question, there are only the first and second is most important. First case, the company needs to be in the Europe. In Europe, the second is the data subject needs to be in Europe. You may do it from any other place. Does it make sense? Can I move on? I can't see chat, so I'm not able to answer. Can someone let me know if there's any doubts or any questions? All right. So I don't think there's anything here. So there are a couple of examples here. The first case, if you see here, a car manufacturing company headquartered in US has a fully owned branch office located in Brussels, overseeing the operations in Europe. The Belgian branch can be considered under GDPR because it exercises real and effective data in light of the nature of the economic activity. Because the Belgian branch is sitting in Europe under the 3.1, hence it will be under the scope of the activity. In the second case, a hotel and resort chain in South Africa offers package deals through the website available in English, German, French, and Spanish. The company does not have an office, representation, or stable union. In this case, in the absence of any representation or stable arrangement of the hotel or resort chain within the organization, it appears that there is no entity linked to this data. However, if there is any subject who is part of this union. Now, because this company was in Europe, in South Africa, it is not applicable. But if someone from Europe decides to go and apply for a South Africa tour, then his data will come under GDPR. That's what it means. So what does it say? In case of there is an absence of any representation or stable arrangements of the hotel and resort chain within the union. There is no chain because the South African company is only located there. All you're doing is that you're working with the territory. Therefore, the data controller in South Africa cannot apply. So there is no entity that is applying with GDPR. Therefore, the stake with respect to 3.1, this is 3.1, is not applicable. However, it must be analyzed in total whether the processing carried out by this data is established or can be collected. Which means if your data, you're not based out of South Africa, but if you're processing data subjects, right, only those 10 or 12 data aspects will be part of GDPR. So Article 3 is all about the territorial scope. Article 4 tells you about the controller or processor. So data controller determines the purpose and means of processing personal data, whereas a data processor is responsible for processing data on behalf of the controller. So you have to be very careful here, guys. It all depends on where you stand. In the first case, a CEO decides to process HR recruitment data that includes personal data. CIO implements the IT system to process personal data. In this case, the CEO is the controller and CIO is the processor. The CEO goes to the CIO, the chief executive officer goes to the chief information officer and tells him to process HR data. So the CEO is the controller and the CIO works on behalf of the processor. In the second case, the CIO now goes and talks to the manager of the software team and asks him to process data on his behalf. So for employees in the IT department, the CIO decides to process the same HR data of applicants with IT experience and instructs the manager of software development to design a software to generate a report. In this case, the same personal data, the CIO becomes the controller and the manager becomes the processor. So it all depends on where you stand. I come and give the data to the bank becomes a controller. The bank then turns around and gives it to a third-party vendor. The bank becomes the controller. The processor becomes a person who's from the software team. Now, the software team decides to turn around and outsource it to another person. So the software company becomes the controller. So it all depends on where you stand in this entire game, guys. All you need to understand is that at different points in time, you may be a controller or a processor. And that is what is very important for you to understand. The moment you decide what can be done with the data, then you become a controller. In India, this name is called fiduciary, whereas in other places, we call them as controller. Then I'm going to spend a little bit of time on Article 5. This is the principles that we discussed. If you go back in this article, we said Articles 5 are all the principles of data processing. And this is where all the other standards came up. So first and foremost, you have to have a lawful data of processing. This is also there in Article 6, which I will come in a second, in a bit. You have to process your data in a lawful, fair, and transparent manner. When you have data of your data subject, you have to have any one of these conditions, 6 conditions to be met to make sure that your data is processed in a lawful manner. First one is there should be consent. That means there should be a consent between you and your data subject to allow you to process data. Today, you go to a mall and then people come and ask you for a number. And the mall goes and outsources this to another party and they start calling you for different reasons. That is not consent. I went and opened an account in a bank in India. Now, I opened the account and within 10 minutes, 15 minutes, they started selling me data for uh, life insurances. They started giving me data for loan. That is not consent. I have not allowed you to consent me for this. Second is that there is a contract. Tomorrow you go and open an account for a loan. During that period, if I have data, that is lawful basis. Third is it is required for a compliance purpose. I want to go and pay my taxes. If I have to go and pay my taxes, or I'm going to say the passport, I'm going to the airport. At the airport, I'm trying to submit my passport. At that point in time, I need to make sure that I'm compliant as per the laws of the land. That is when it is required. Fourth is the vital interest of the data subject. Now, what is the vital interest of the data subject? In case I'm going for an election. And in the election, I need to go and cast my vote. During that period of time, because I want to cast my vote, I need to give my personal data. Then it is in all fairness. Fifth, it is for public interest. Tomorrow there's a earthquake, and Sri Lanka had in November last. You had a big cyclone, and during that period of time, I'm supposed to identify who you are. So in that public interest, to know who you are, where you are, it is important for me to take your data in that aspect. For the third, there's a legitimate interest. I am part of a business. I'm a bank. I am a hospital. I go to a hospital. It is required for me to process your data. Otherwise, it's not so. I just walk up and ask you for your number. It is not really legitimate. So if any of these 6 buttons or any 6 of these 6 options say tick, then it is a lawful basis. So you need to ask your controller, or you need to ask what is the basic reason for you to collect your data. Second is purpose. And this is an important aspect again. As a data subject, you have all the right to ask where your data is going to be processed. What is the purpose? Why have you collected my data? So to process data for legitimate purpose specified explicitly to the data subject when you collect it. And this is for GDPR. It may be for PDPA, I'm not sure. But when you have a GDPR-based requirement, you have to let them know what is the purpose for collection. and he has all the right to decide not to give it to you. Record your purpose as part of the documentation obligation and specify them in your privacy information. So you have to call out and say, I am collecting data for a survey. I am collecting data for opening a bank account. I am collecting data for sending a report to you. You have to be very careful what is the purpose for collecting data. A lot of times in India, we go and drop a card in the malls and we don't know what and how that card is going to be used. So you have to be very careful when you provide data to any associate anywhere in Europe. And if it is also there in other countries, so be it. Yes, even DPDA in India has solved this. Even PDPA has got this in Sri Lanka. You have to have a purpose limitation. What is the purpose you're using it for? Once the purpose is over, you should delete the data. If you need it for any other purpose, you have to collect it again. I have collected data for opening an account. I've opened my account, then now I want to go and sell him an insurance. You have to collect the data again. You cannot use the same data because your purpose is over. Third is your minimization of data. How many fields would you like to collect? And I had this experience when I was in UK. There was a survey done, and the survey had around 200 fields that was being collected. 200 fields, not one, not two. Now it is a big challenge for us when you have to collect 200 fields because your name, address, phone number, your wife, your salary details, your how many fridge do you have, how many vehicles do you have, how many places do you travel to, what places do you like to travel to. It's absolutely not required. What is the purpose? As per the purpose, collect as much information as necessary. Collect and process only the data which is necessary. Do not collect anything more. Ensure that the personal data you're processing is adequate, relevant, and limited to what is necessary. Otherwise, it is an absolute waste of time and effort for you to collect data which is not really required. And I've done surveys. I'm sure some of you may have also done this, where they ask you for your number of vehicles that you have, number of holidays that you go to, which hospital holidays do you go to, how many times do you go, how many kids do you have, how many books do you read. Absolutely not necessary. Fourth, the data has to be accurate. And it is important for you to allow people to change data. Right? To keep the personal data accurate and up to date, take all responsible steps to ensure personal data that you hold is not incorrect. You should allow the data subjects to change your data. Next is storage limitation. So as per information security, there's a concept called data retention. So any data that you have should not be kept beyond necessary. I have got my purpose, I've collected my data, which is limited, I have accurate data, but any data after the purpose is not required. I've collected it from a bank. Yes, once my account is over, you should delete my data. Unless there's a requirement by the regulatory body. Otherwise, your data need not be. If I close my data, you have no other business to come and talk to me. I closed my account in a Indian bank almost 4 years ago. Yesterday, I still got an email from them. So you should be careful, guys, that accounts, if they are not really required, you are supposed to close it and not take care of and do not use the data anymore. So store personal data as long as necessary for specified purpose. There should be a policy for data retention and review the data periodically, erase or anonymize when no longer required. Next, there should be integrity and confidentiality. What does integrity mean? The data should be accurate and authentic from the start till the end. Your data should not change. I had my name in my passport. I had a given name, and there was no surname for almost 2 passports. In India, the passports run for 10 years per passport. That means for 20 years, I had a name which was incorrect. So there was no surname given. So for me, when flights used to take place, I'm sure most of you may have traveled abroad. So they give you your surname first and then your first name. Because I didn't have a surname, so my name would be either FNU, which means first name unidentified, or LNU, last name unidentified. So only one name would be there. That's the incorrect data. You should allow the data to be changed. Your names get changed in your passports or in your other government body organizations. You should be able to change your data. Similarly, your data should be confidential as much as possible without others knowing your data. It is not necessary for others to know who you are. So processing must be done in a way to ensure appropriate security, integrity, and confidentiality. And the last one is accountability. End of the day, where does the buck stop? The data controller is responsible for being able to demonstrate GDPR compliance with all these principles. It requires to take responsibility for what to do with the personal data and how to comply with other principles. Ensure appropriate measures and records in place are there to be able to demonstrate compliance. So as an associate who is part of as a controller, you have to ensure all these articles are being covered, these principles, right from lawfulness to purpose limitation to data minimization, accuracy, storage, integrity, and accountability. Once this is done, your next ones are with respect to this is the lawful processing, which we covered as part of your Article 5. So Article 6 talks about, which we just covered, you should give consent. Without consent, and I'm sure some of you may have noticed this, when you go to certain websites, it'll tell you that this has got cookies, and please let me know whether you're okay to allow cookies. And only if you say yes, you'll be allowed to move further. So you need to have a contract. There should be a legal obligation, which I was mentioning a little earlier with respect to maybe a creation of your passport, or you're at the immigration desk. Next is with respect to protecting your vital interests. Tomorrow I have to cast my votes. Next is public interest or legitimate interests. So these are the 6. Any one of these 6 need to be applied. 7 is consent. So you have to give consent for your data either implicitly or explicitly. So how do you give your consent is all Article 7. I'm not going to read through them. This is something that you can take your own your time. And where the car is based on the consent, the controller should be able to demonstrate that the data subject has consented to processing of his or her data. So you have to be careful in terms of how your data is being consented. So some places it is explicit consent, in some places it is implicit consent. What do I mean explicit is that I explicitly ask you to sign my data. That means you are using my data. Second case, it is implicit. Maybe your cookies that I'm collecting is a implicit data that I'm collecting. So every once in 3 months or 2 months, if you clear your cookies, that's the way in which they will ask you to re-enter your data all over again. And they'll say, can I use it for certain activities? So what are the conditions under which your consent can be collected? And then 8 is child's consent. So there is a separate article under GDPR with respect to child consent. So as per GDPR, they are talking about 16 years. But in certain member countries, when I say member countries, some of your other 27 countries that you may have, the age limit may be lower or higher. So GDPR is of the opinion, GDPR says there needs to be a consent age for a child, which means a child you cannot collect a child's data without the consent of his or her guardian. If it is a child less than 16 years, you have to take from the guardian. So tomorrow, if I have to take the data of, I'm going to a pediatrician or I'm using data for a particular at a particular event, you need to take the permission from their guardian that this data will be used for this particular purpose. So Article 7 is about taking consent of an adult. So there are multiple places. The second one, which talks about the consent given in a written declaration form, which also concerns matters. The request consent shall be presented in a manner which is clearly distinguishable from other matters. Now, this happens a lot of times when you go for a contract. And at least in India, we see a contract when I go and sign a loan agreement. My loan agreement will be for around 30 pages, and there'll be huge lot of content that I'm signing for. But nowhere does it explicitly talk about consent. And if that comes up, then you can put a penalty against Article 7. So it has to be in a very, very clear and distinguishable manner, using clear and plain language that I need you to give me consent. There are other pieces. How to withdraw consent is again something that you have to be careful of. You should allow people to withdraw consent, which I'll come to you again as part of our rights. So consent can be as easily as you're giving consent, you should also be allowed to withdraw consent. And similarly, you need to be at least 16 years old And some country member laws may provide a law for lower age. In some countries in European Union, the age is come down to 14 years. That means till 14 years, the child cannot give his own consent. After 14 years, the child will be able to give his or her own consent. In India, it is 18 years. And in 18 years, my kids have decided to open an account on their own after 18 years. 9 is special categories, which is your SPII, sensitive data. So if you are processing any data which is sensitive in nature, it will comes under Article 9. Article 10 is criminal convictions. So this is an important piece again. If at any point in time I'm capturing sensitive data, which is Article 9, or I'm processing any criminal data, which comes under Article 10. So they shall be carried out under the control of official authority or when processing is authorized by the EU law or member state laws, providing for appropriate safeguards for the rights and freedom of data subject. Any comprehensive register for criminal convictions shall be kept only under the control of official authority. So if you are processing personal data, you will be under the Article 10. If you're sensitive data, you'll be Article 9. Child data, Article 8, and consent will be Article 7. Then there's another article where it also gives you freedom to collect data, which is where you don't need to identify, you don't need to take consent. And this is mostly which is in the public domain. If the purpose for which a controller processes personal data do not or no longer require identification from a subject, the controller should not be obliged to maintain, acquire, or process additional information. For example, if my data is in the net, I don't need to take data from you anymore. So you don't need to give me permission because you have already given the data on the net where you come and write my name, my address, my phone number, my registered email address. You are a director in your company. You are given your public domain. You have a DPO, your data privacy officer. Then you don't need to give my data under the Article 11. This is another section which we will cover with respect to data subject rights. I'm sure some of you may have seen this or heard of this. But this is where the rights of the data subject came out in particular, and there are almost 12 or 13 articles under the data subject rights. So Article 12 is transparent information, communication, and modalities for exercise of the rights of the data subject. What it means is that you are a data subject, you should be very clearly told how will you get to collect your information. That's all it means. Transparent information communication and modalities for exercising of the rights of the data subject. So you as a data subject need to know your rights. What rights do I have? Can I change my data? Can I transfer my data? And these are rights later when I'm coming to. So Article 12 mandates you as a controller, you should inform the client or the data principal what are his or her rights, and it has to be transparent. It is not something which you will quietly put in one document and not share it with them. It has to be on the face. And I was doing this consulting in UK. It was put up as a document, it was shared as a PDF, and it was also put on the notice board. So it's called the rights of the data subject. There has to be a policy or a process which allows you to know what rights do I have. And what are some of the rights? We'll come later. Article 13 states information to be provided where personal data is collected from the data subject. You are a data subject. According to Article 13, you can go to any European office. Say you're going to a Bank of England, you can walk on and say, as per Article 13, please tell me all the data you have collected of me directly, which has been collected from me. So I need to know, you go to a bank today, if you go to any Sri Lankan bank or any other place and you ask them for your data, you know what answers you'll get. So Article 13 says, you walk up and say, I need to know what data I have collected. Article 14 says, what data have you collected without my knowledge? And this does happen. A lot of times you may collect a lot of data which I have not provided. You were collected from other suppliers, from other vendors, and other agencies. You may have collected my data. So you have all the right as a European citizen, walk up to any of the organizations and under Article 13, find out what have you given, and under Article 14, what have you not given, but they have collected from other sources. And they have to mention the source. I've collected this from Reuters, I've collected this from your website, I've collected this from your friend. You have to inform them. So what are the different rights? Right of access, which means that your information, you should be in a position to access your information at any point in time. And today, thanks to your mobile apps and thanks to your SMSs, your information is on your fingertips. So today I can put an SMS and then I can get my credit card score. I can get my bank details. I can get my address changed, all at the fingertips. So the first right comes as per Article 15, which says you have the right to access by a data subject. So you can walk up and say, I want my data and I should have accesses. Either I go to a bank, I can go and do it through a website, or I can do it through an SMS. You should have a right to day. Article 16 talks about right to rectification, which means you should be allowed to change your data, which is similar to the principles because we spoke about these principles a little earlier. We spoke about accuracy. If you don't allow your data to be accurate, then there is no point. So you'll not be able to rectify your data. I had this challenge. I had an account in Citibank almost 7 years ago. And when I was changed addresses, I was from a owned house. I went to a rental house. Citibank refused to change my address. Citibank said, we don't allow your proof. I need a government proof. I said it is not owned. I earlier used to own a data, my house. Today I don't own the data, but I am moving to a rental place. Citibank refused to allow me to change my data. So then I had to cancel my entire Citibank account and move on to another bank. So it is as per the rights of Article 16. You have a right to change your data at any point in time. And some of them you can change. Today, if I am with any other bank, I'm allowed to change my address or I'm able to change the nominee, but some primary data I will not be able to change. I can't change my phone number. I can't go and change my name. That will be as per the government records. So it is difficult for you to change certain fields, but the other fields you should be in a position to change. Next one is right to erase. So my consent, I don't want to give my consent anymore. I want to remove my data, my requirement. I don't want any emailers coming from you anymore. You should be able to forget your data. So there is this option called unsubscribe. I'm sure some of you may have seen this. Unsubscribe is when you are able to remove the data that you had and you don't have it anymore. That is called the unsubscribe version. Right to erase. You have given cookies. Now after that, you don't want it anymore. You should be able to, and you should stop getting activities anymore. Right to restrict or processing. This is a little tricky to understand. Now you go to a bank and you tell them, I don't want you to process my salary. That will not happen. You go and tell them, I don't want you to process my my reports that you want to give to the bank. That is not possible. But there are some cases where you should be allowed to restrict processing is in case your data is incorrect. You can always go back and say, please don't process my data because my data is incorrect. My name is incorrect or my address is incorrect. So you should be allowed to restrict your processing of that particular data. I got an invoice in one place where the data was incorrect. So I told them that this is not correct. So please don't process this data. Only in cases where my data is incorrect, you will be in a position to restrict processing, whether I'm holding, whether I'm keeping it with me, whatever may the case, or maybe my passport has changed. Today I've got a new passport. So my old passport is no longer valid. So you can go and tell them, please don't process my old data. Article 19 talks about notification obligation regarding rectification or erasure of personal data or restriction of processing. So if I have invoked Article 16, Article 17, Article 18, I have a right to get a notification, which means as per Article 19, the controller or the processor is mandated to send you a notification either through an email or through a WhatsApp or through a confirmation call, any of these cases, if you have done your notification, there should be a confirmation that comes in. So what does it say? Notification obligation. So the controller has an obligation to notify you in case you're rectifying, you're erasing, or you're restricting processing. So thank you, Mr. So-and-so, so-and-so. We hereby confirm that your address that you have given has been changed in our records, and it will take another 2 hours to reflect it in your book. So thank you very much for your services, and do let me know if you have anything else to confirm. Article 20 talks about right to portability. Now, some of this is not applicable in other geographies or in other standards. You have a right to port your data in EU. So if I'm in Bank of England and I want to move to Bank of Scotland, I should be allowed to port data from one country or one bank to the other. So you can go and tell them, I want to move from your bank to another bank. Please give me all your data, allow us to transfer. Now this has happened, CCERT being a certification body, even in audit, even in certification life, you can change from one certification body to another. Similarly, in India, there is also numbers. Your phone numbers can change from one carrier to the other. I'm with Airtel, and from Airtel, I want to move to another carrier. I just inform, and then my number can get ported. Similarly, I should be in a position to port my data from one to the other. Right to object. Right to object is a little different from restriction of processing. Right to object is that there are certain things that you may not want them to do. Like say, for example, emailers. You have a right to tell them, I do not want emailers at all. I don't want any marketing activities. So there are certain checkboxes. So if you go to certain sites, there will be a checkbox which says, do you wish to receive any promotional material? You should say, no, I don't want. Okay. So, or there's any other activity that you don't want to be part of, you have a checkbox. You have all the right to come and say, I do not want this to be taken care of. Article 22 talks about automated decision making. Now, this is a very, very sensitive thing that is coming up thanks to AI. Due to AI and due to the LLMs, the learning models that are coming up, there's a huge amount of automated decision making that is taking place in terms of emailers and whom all should they may the blast go to. So there are times when your number gets fed, and every 10 days or 15 days, you get bombarded by emails that come out. And so this is a common factor. So this keeps getting regularly reviewed. So you have a right that you do not want companies to do automated decision making. Decision making has to be manual. So you cannot come and say, okay, please send us details of all the people above the age group of 30 and who have a revenue or who have their account of more than $50,000. Please send an emailer to them with this kind of marketing gimmicks. So there is a requirement by most of the management companies where they want to send out a blast. And your job, as per Article 22, is to make sure that you do not do any automated decision making, which is called profiling. Profiling is a very strong word that is used. Profiling is, like I said, it could be Hispanic, or I'm looking at Afro-Americans within this age group or in this particular area. So these people you should send an email to them. That should be stopped. And the last one is important with respect to restriction. Now, all these that you saw from 12 to 22, all happens as a rights of a data subject. So as a data subject, you can do all those aspects, except in 23, there are certain places or restrictions against which you cannot do there are no rights of a data subject. And what are those restrictions? If I have a criminal record, which is Article 10, and you saw somewhere you have got Article 10, if I have got a criminal record or a civil case running against me, I don't have a right to access, I don't have a right to rectify, I don't have a right to put any of those activities. Or if there is anything from a national security standpoint. Now, tomorrow there is a requirement where you have your name has come out as a as a national security requirement or as a defense requirement or as a public activity, your name cannot be kept quiet. Tomorrow there's an emergency in the organization or there's a public interest. Now you saw this rights of the public interest in number 6. If there's a public litigation, public interest, your name cannot be, you cannot stop. The restrictions are there. So either of a civil case or as a military case, a defense, security of the organization, security of the company, of the government, my bad. So if you have got a criminal case, there's a red letter happening against from FBI, or you're somewhere in Europe, you have run away, you have murdered a few people, you can't come and say, please don't send it to me. Don't publicize it. Or if there's a civil case or a criminal case or there's a security, national security requirement, your restrictions cannot take place. So the article 12 to 23, which is chapter 3, is all about the restrictions that you have. Article 24 is all about controller and processors. So this is something that you can have a look at. So what someone muted me? Guys, can you hear me now? Hello? Dishmika, can you confirm that you can hear me now? Hello?
Yes, sir, we can hear you.
Okay, there was some place where it got muted, so that's what I was wondering. Okay, now coming down to chapter 4, we are almost on the last leg now. We got under 45 minutes. So we are in Article 24. So 24 talks about the responsibilities of a controller. What does a controller do? Article 25 talks about the protection, data protection by design and default. So Article 24, what is your responsibilities as a controller? All the laws of the land, making sure that your data, all the principles are being taken care of with respect to transparency, lawful processing, integrity, all that needs to be taken care of as a controller. And then how do my data get protected? Article 25 talks in terms of how my data gets protected as per design and default. So in your software engagement, there is something called privacy by design and privacy by default. What are those technology controls that I will meet with to protect my data? Either I'm going to encrypt it or I'm going to pseudonymize it. What are those aspects I will do is part of my data protection. Article 26 talks about joint controllers. In case you have more than one controller, they are called joint controllers. For example, tomorrow you are traveling from Sri Lanka to US. Now you might take a Sri Lankan Airlines from there to Singapore, and from Singapore you might take a Singapore Airlines. So you are traveling two airlines, that is you got Sri Lankan Airlines from Sri Lanka to Singapore. From Singapore you take a Singapore Airlines. So there are two controllers who will have your data. So your data baggage, which goes from Sri Lanka to Singapore, will be with Sri Lanka. And from Singapore to US, you'll have a second carrier that is called a, there are two parties or two or more parties are involved are called joint controllers. So when for one particular activity, you have two or more controllers managing your services is called a joint controller. All right. EU representative of controllers or processors. Now, this is something which is new to this particular standard, which is not there in other standards. This is in case you are a controller or a processor who's outside EU, but you want to process local data. It's like what we do in other countries. When I want to go to other countries, I will call someone and ask him to be my contact person. Now, this contact person will be my go-to spot in that particular country. Similarly, if I have a if I am a controller or a processor processing an EU data and I don't have an office, the EU GDPR states and mandates you to open an office with a representative. Now, this person is a shared person. Now, he will be like a branch office of yours, but you need to have a local presence to make sure that that part of that processing is compliant. So for example, you are now in Sri Lanka and you're processing a lot of Sri Lankan data. Tomorrow you want to start processing data from, say, Italy. Now, because you are trying to process some Italian data, you need to have a representative for till you open your own branch office. You don't have the money, you don't have the skill set to open an account. So you will tie up with a local body there and he will be your representative. So if anything happens to you, to that particular person, the representative will be the first person responsible to handle your data. So as a representative, you are almost like a branch office and you will be the eyes and ears for the company who's sitting outside. And this particular representative will be governed by the EU, by the GDPR Act. So Article 24 to 27 is all about what you can expect of a controller. So there are a lot of responsibilities, and I will strongly suggest that you have a look at the responsibilities and what are the documentation that you need to have as a controller, and then what are joint controllers and what are representatives is as Article 24 to 27. Then you have a processor, and what does a processor do? He works on behalf of a controller. So very, very important to understand that a processor can and only work under a written agreement with a controller. Now, if the written agreement is not there, then the controller's work is no longer valid, number one. Number two, if the processor is doing work outside the agreement of the controller, then the processor also becomes a controller. Let me repeat. I am the bank and I have outsourced it to one ABC corporation. Now, he's my processor. Now, I as a bank, I'm allowing ABC corporation to do my work. Now, he's my processor. At some point in time, the ABC corporation decides to outsource it to another EFG company. Now, this EFG company, once he starts becoming a control, he starts outsourcing, the ABC then again becomes a controller. So he does not no longer becomes a processor because now he can decide what needs to be done. So if that happens, then this agreement becomes nullified and then this works out. Article 39 talks about processing under the authority of the controller or processor. Now this happens on a lot of times. These are called third parties. Now, to give you an example, there are a lot of third parties who work, they're neither the controllers nor the processors, but they help in the workings of the controller or processor. For example, in India, I can give you an example where my passport number is validated by a third party app. Now I go to a bank and I sign my name, address, phone number, I give my national ID or I give my passport. That passport number gets ticked and goes to a third party, and the third party validates my number and gets it back to me. So where your data gets validated for certain activities by a third party, and they're called third parties because they're neither controllers nor are they processors, but they are people who are supposed to validate your data. That activity comes under Article 29, where you're processing on behalf of a controller or processor only for certain activities that are expected out of the processing of data. It happens in a lot of cases in India. We validate our phone numbers, we can validate our passport details, we can validate our national ID called Aadhaar. So there are certain digital apps where you can do that. I'm sure there must be something in Sri Lanka also where your validity of your data is in that app. That comes under Article 29. Article 30 is called ROPA, Records of Processing Activities. And this is a short form called ROPA and in PIMS Privacy Information System. ROPA is nothing but a set of data that gets collected and a record of what all data are you collecting, my name, my address, my phone number. So records of all those templates of all the data. And if you search in your on the net, and you can go to the net and you can type something called ROPA, and I'm sure you'll be able to see this happening. And if you go to your Google Drive and you can type ROPA and just type So this is, you got templates, which are free templates, which gives you all the data that you can collect, your name, your address or phone number, anything which is called records of processing, which means what are my different records that I wish to use. And if you want to type template, so you have different templates that you can collect, and this is free downloads. You can collect it from any place you want. So it will have your this is a free download. Let me try and open this for you. So it has all the fields for my customer. I'm collecting it for customer ticketing, and it gives me the whole history of what all activities I'm doing. What is my description? I'm collecting data handling customer inquiries. I'm a controller. This is the purpose. These are the fields, and this is the volume. So it gives you a total inventory for what you do as a customer, what do you do as for communication, what am I doing for finance, what am I doing for HR. So a ROPA is basically nothing but an inventory of the different activities that you perform during the course of your journey. I'm sorry I'm going fast, but that's all I have because I have only 45 minutes. That's why I have to run this through. So you need to take care of your ROPA activities. Article 31 talks about cooperation with the supervisory authority. So as a controller or a processor, you have rights, and you have rights as a controller or processor, but you also have rights to connect with the supervisory authority, which means the governing body for data privacy operations. So tomorrow, if there is a data breach or something happens, how do you work with them? So what is your cooperation? You have to ensure that you give them the data at the earliest and you do not delay. So there are 3 or 4 activities that you will do as part of your cooperation of the supervisory authority. Article 32 is your processing. How do you put security against your processing? What do you do with respect to pseudonymization, encryption, with respect to CIA, confidentiality, integrity, availabilities? And with respect to proper testing, make sure that there is no unlawful destruction, loss, alteration. So there's a lot of activities of how do you securitize your data is part of Article 32 that you need to take care of. At your own free will, please read this through. This is this is quite an important thing. But some areas I want to put focus. That's why I'm going to stop there. Article 33 is about data breach. So as an associate who's part of a controller or a processor, if there's a data breach, you have to inform, and this is a mandatory requirement as per the standard, as per GDPR, that you have to inform your supervisory authority within 72 hours. Right? So in case of a personal data breach, the controller shall, without undue delay and where feasible, not later than 72 hours, should be aware of the personal data breach. And what all am I supposed to give? I have to give details of my personal data breach, communicate the name and contact details of the data protection officer, describe the consequences of the data breach, and describe the measures taken. So here I have a data which has breached. The data of my name, address, phone numbers of around 150 people have been lost. And this is the activities that are going to take place. And these are the things that we have done. We have now restructured it. We have added additional controls. So you need to inform the data subject, the supervisory authority. So Article 33 is informing the supervisory authority. Article 34 is informing the data subject. The good and bad part of data of GDPR is that as a controller or processor, there are sometimes the standard is telling you that you do not need to inform the principal. The irony is that it is my data. I am mandated to inform the supervisory authority, but I am not mandated to inform the data principal only if there are certain areas. And I'm going to come to that. When the personal data breach is likely to result in high risk to the data rights of the freedom of natural persons, the controller shall communicate the personal data without delay. But there are some places where I am not mandated to inform. And what are those? The controller has implemented appropriate technical and organizations protection measures, and those measures were applied to personal data affected and makes them unreadable. For example, if my data is encrypted and you have taken my encrypted data, it is of no use to you. So I don't need to inform the data principal. Second, if we have taken subsequent measures to ensure that the risk is referred is no longer likely to materialize, which means that my database has now been removed from the net. You cannot access my database. That's another case where I don't need to inform the data subject. In the third case, where it is disproportionate effort, all you can do is you can put a public communication. For example, in certain cases, I'm sure you would have seen TikTok or other places, public platforms, there were some 10 million records which were stolen. Now, I cannot physically go and inform all 12 million people. It becomes very, very difficult for me to do that. So what do? I'll put a public message and say, there are 12 million records that got stolen or got locked. And if you are among them, just log in for you to find out whether you're one of them, log in. And if your ID is this, or if you get a message, then yours is stolen and please contact me. So all to remind you, 33 is you have no choice, but you have to inform the data subject, supervisory authority. But if you are any one of these three where your data is unintelligible, which means you have encryption or you have pseudonymized it, your data is not readable anymore, or if you put measures where you cannot access it, or it's too voluminous, you don't need to inform the data subject. Article 35 talks about DPIA, which is a data privacy impact assessment, which means that when should I do a data privacy impact? So Article 35 has certain aspects that when there's a new data or when there's a new service or when there is sensitive data or when there's criminal data. So there are 5 or 6 checkpoints of how and when should I do a DPIA. That comes as part of Article 35. Article 36 talks about prior consultation that needs to be done with the supervisory authority. So in the controller shall consult the supervisory authority prior to processing DPIA, which indicates the processing would result in high risk. Tomorrow, say for example, you have data that you are collecting for sensitive data like criminal cases, or your sensitive data of say religious in nature, or you're collecting data of certain credit card details. And if you think it's of high value, before you do a DPIA, if you feel like as per Article 36, you have a right to consult. So Article 36 gives you a right to consult with the supervisory authority to see whether you should conduct a DPIA. And these are some of the conditions, like I mentioned. If you're using new technologies, you're tracking person behavior, you're processing personal data, ethnical data, all this will be part of DPIA. Article 37 gives you the designation. 37, 38, and 39 are all about the DPO. So Article 37 talks about a DPO required only in 3 cases. And this is important for you to understand, guys, that the processing is carried out by a public authority or your core value, there's a high volume of data, or you're processing criminal data. Any of these 3 cases, only you need a DPO. In other cases, you don't need a DPO. You can call them as a DPM or a DPL. So only if you are a public authority or you're processing large amount of data, which is maybe around 10 million data, or you're processing special categories of data, or you're processing criminal data as per Article 9 or 10, then you have a DPO. What does a DPO do will be part of 8 or 38, and what are the different tasks. So you can please read them. 37, 38, and 39 is all about what a DPO does. Article 40 talks about a code of conduct, which means how should you behave as per GDPR. So there are some articles of 40, 41. How do I monitor my code of conduct? And then how do I transfer data? There's a separate session I would like to do, but I'm not going to get into. There is a concept called binding corporate rules, or an SCC. SCC is standard contractual clause, or BCR is binding corporate rules. There are 2 different methods in which data is transferred. One is in case you are a controller to controller, controller to processor, processor to processor, processor to controller, you have something called an SCC. SCC are transfers which are between one company and another company. I am transferring data from my company to ABC Corporation, then you will use SCC. BCR is when you are wanting to transfer data within your own company. and your branch companies. I am in the head office. I want to transfer data to my branch office. I will do something called a BCR. I'm not going to get into this, guys. There is a separate session that I'll work with you, but it is good for you to understand the different frameworks that you will use for transfer. So there are different use. What is a transfer rules? What is an adequacy decision? You remember I was talking about adequacy provisions. So there are 9 or 10 countries. How do you transfer data? What are the different appropriate safeguards that you will use? Safeguards is in terms of my data protection, in terms of my transfers, in terms of my encryptions, in terms of my validity. What are my different rules? How do I transfer? Do I disclose my transfer? Transfer or disclosure not authorized by union laws. So if there are any transfers that you are doing which is not allowed by union laws, for example, in India, when we had a nuclear blast, US put an embargo on us and told us you cannot transfer any data. So if that happens, you have to inform. What are the special conditions where I cannot do it? What is my internal cooperation that I need to do? So please read them through. These are quite important that you need to work with. Entire Article 51 to 59 is all about the supervisory authorities, also called DPA, Data Protection Authority, Information Commissioner, Privacy Commissioner, etc. What are their rules? 51 talks about the supervisory authority, their independence, the general conditions, the rules of establishment, and some of their competencies. What is the competency required? So there are a lot of articles with respect to the specifications of the supervisory authority in each area, their task, the powers, and how do they report. And here there's something called a lead supervisory authority. Please understand, in certain countries, there might be multiple supervisory authority. My head office is in say France, but I have branch offices in Germany and say Italy. Now, each country will have its own supervisory authority, but the lead for that data might sit in France. So what is the role of the lead supervisory authority against the other authorities? So this is from Article 51 to 59. And this is the other big one which I want to complete before I close is your penalties. So this is another thing that you will come and bite you. This is something that I just showed you before we went out is your penalties that we were looking at. So there are a lot of penalties that the company has on their own. And these penalties is something that you will notice, which is called the enforcement tracker. So who gets what penalties? So as per the rules of the game, Article 77 talks about, is from 77 to 84. Article 77 is if you want to lodge a complaint with a supervisory authority. So tomorrow you are a data subject and you want to raise a complaint with a supervisory authority, you can use Article 77. And if you want to raise a complaint against a supervisory authority, it is Article 78. 77 is you are raising a complaint to a supervisory authority. 78 is if you are raising it against a supervisory authority. 79 if you are raising it against a controller or processor. So see, what does it say? Right to lodge a complaint with a supervisory authority. Second is right to effective judicial remedy against a supervisory authority. Right to effective judicial against a controller or processor. Article 80 talks about representation of data subject. What does a data subject do? Who can represent a data subject is Article 80. If he wants to suspend, he can suspend it using Article 81, says suspension of proceedings, which means you no longer want to raise a complaint against 77, 78, 79, you can suspend it. Article 82 is the right to compensation and liability. So if you want to get any money from a controller or processor, you will use Article 82. Article 83 is when the fine is imposed by the supervisory authority, and 84 is penalties. So let me repeat again. 77 is when you want to lodge a complaint with the supervisory authority. 78 is against a supervisory authority. 79 is against a controller or processor. 80 is when you want to represent a data subject. What does a data subject do? 81 is to suspend. 82 is when you want money from the controller or processor. So tomorrow, if you want money from the controller or processor, you can use Article 82. Any fines imposed by the supervisory authority is Article 83 or 84. And what are the different fines? The difference between a fine and a penalty. 83, if you notice, was fine, and 84 is penalty. So what is the difference between a penalty and fine? A fine is levied by a court, where a penalty is by an appropriate authority. When I mean a tax, if you are not paying your tax, you'll have a penalty. The penalty will be 10% more that you have to pay. But when you go to you break your laws, you in a traffic signal, you get a fine. You don't get a penalty by the traffic rules, you get a fine. But when you don't pay your comfort, then you pay a penalty. A penalty does not involve court proceedings. It is imposed by a person who does not comply with the provision, whereas a fine is money which is paid by a court. So you either pay a fine or a penalty, and this gets defined based on the nature and gravity and duration of the infringement. How many times have I altered? Have I done it once? Have I done it twice? Have I done it 3 times? How many times have I done this? Intention or negligent character of infringement. Do I know, is it happening intentionally or is it done properly? Degree of controller or processor's responsibility, level of cooperation, type of data involved, way of infringement that you got to know. Did you get to know from someone else? Did a data subject inform you? Was it a controller processor informed you? Or was it through other factors? So what are the two types of fines? The first fine is of 10 million euro or 2% of the turnover. Second level is 20 million euros or 4% of the revenue. And what are these tables? This is a table that gives you the entire overview. If you are violating any of the articles on the left bucket, you will have to pay 10 million euro for each incident. Let me repeat again, for each incident, you will have to pay up to 2% of the turnover. It is not a maximum, it is up to. Any articles from 8, 11, 25, 26 up to 32, 42, if you don't pay, you will have to pay up to 2% of the turnover or 10 million euro. If you are any of the on the right side, it is more severe. See, principles related to processing, lawful processing, your transparency, your storage limitation. Any of those you do Article 5, Article 6, 7, consent, 9, special categories of data, transparent information not being provided. Your rights of the data subject, 12, 13, right up to 22. Transfer. Any of these are not provided, you can be levied up to 4% of the turnover. So 2% or 10 million euro, 4% of the annual global turnover or 20 million euro. I was working for this company in India. The annual turnover of that company was $4 billion. But one of the customers that I was managing was 40 billion, was $80 billion. 80. So $80 billion, 4%. So 3.2 billion, it would have wiped out 90% of the turnover of that company. So it's very important for you to understand that your penalties are very, very important for you. And the next two slides are just meant for your own obligation. So if I was talking about the article, this is your chapter 10, which is your articles. When I'm processing and freedom of expression, I'm processing for official documents, processing for national identification, processing for church and other religious organizations. Article 85 to 91 is for specific processing. Processing in the context of employment, safeguards against archiving purpose, for public interest, scientific, historical data. This is something that is just meant for your own purpose. You can read this at your own free will. And then Article 92 to 99 are delegated activities. How do I delegate my work to others? Is all about Article 89, 92 to 99. So before I go to the last slide, your articles 1 to 11, you had 11 chapters. So this is to make you look at an idea of what these all were. Are there any questions you have for me till now? All right. So before I conclude, there is a overview slide that I have, which will be important for you to understand. And this slide, ladies and gentlemen, is a slide which is meant uh, for you to understand your entire flow of GDPR. And I'm going to take a couple of minutes. So this is a GDPR roadmap, and I'm going to go step by step. So there are 13 steps which you generally try and apply for any GDPR implementation. So if you read this through, it says context, which is the context and scope. Always important for you to understand that before you go for any GDPR implementation, please understand what is the context. Why are you going for it? What are the different areas where you intend to implement this GDPR for? So you need to have a scope, which means which departments. Do I need it for my HR, for my finance, for my IT? What is my scope? Second, you need to make your senior management aware. And in most cases, they're not. Senior management always has a challenge with respect to GDPR. They don't know what data privacy is. They don't know what is GDPR. They don't know articles. They don't know rights of the data subject. They don't know the principles of data subject, of data privacy. I have no clue. Why do I want to go for the standard? So step 2 is always about, once you know your scope, please get your senior management to be aware. Once you do that, please do a data flow inventory. You have to know what are the different flows of your data. Where does that data come from? Where does it go? And then you have to have a legal basis. The 6 bases of legal processing: consent, contract, public interest, your personal interest. Is it meant for lawful basis of processing? Is it for... So what are the different legal bases that you have? There are 6 bases of legal processing. So you need to know, am I processing my data legally or illegally? Once I've done that, I have to manage consent. So there is a separate team called consent management. And this is a quite a active piece that comes out in data privacy today, called consent management. So it's a separate department altogether where you are managing consent on a day-to-day basis. So you have to manage, how are you going to collect consent, how are you going to remove consent, how are you going to update consent. And then you have to prepare a governance framework. You should have a privacy leadership, prepare your policies, have a training awareness sessions, and whether I need a DPO or not. Chapter 38 talks about having DPO if you have a large amount of data, whether you're a public body or you're managing sensitive data or criminal data, Article 9 or 10. If I'm not doing any of these, you don't need to call them a DPO, you can call them a DPL. A lot of companies have this, they call them as a DPL, that is a data privacy lead, a data privacy manager, or a data Spock, whatever you may want to call them. But if there is large amount of data, or there is data which is sensitive, or there is data which is criminal in nature, or it's a public company, you have to have a DPO. So if you don't need a DPO, then appoint a DPL. And then you need to have performance evaluations and management reviews. So once I have done my DPO or my governance framework, I then need to do a risk assessment or an impact assessment. So the risk assessment or the impact assessments need to be performed to make sure what is my risk that I bring to the table, after which I have to prepare my design and default privacy by design and privacy by default activities. What is my privacy? Am I going to look at encryption? Am I going to look at indexing? Am I going to look at data minimization? What am I going to look at? Pseudonymization. What are the different techniques that I'm going to use? So in our IT language, there is something called PET, which is privacy enhancing technology. So some of you may read this through. It is called PET, privacy enhancing technology, which allows you to talk about what is by privacy by design and privacy by default. Then I do my data retention. How much data am I going to retain and for how long? So I need to have a policy, and I need to have a controlled information policy document, which means how do I prepare my documentation. Then I have to have transparency, which is my privacy notice. A lot of companies you would have gone and seen, they have something called a privacy notice. And this is something you would have noticed in any site that you go to. Say, for example, I'm going to a site called, say, Microsoft site. Let me look at Microsoft site. So any site I go to, I click on the site, there is something called a privacy notice, which will be there at the bottom. You'll notice this is what privacy is. It has to be as transparent and it should be communicated to you. What is my privacy statement? What is my privacy for young people? My privacy reports? What all can I do? Whom should I inform? So there is a public notice, privacy notice is what it is called. It needs to be available at your end. So you need to have it should be transparent, which is called privacy notice, and a communication procedures and records, which means how do you plan to communicate? Is it going to be on your websites? Is it going to be on email? Is it going to be physical aspect? How am I going to do a transparency? And then what rights do I have over data subject? Subject access request, do I restrict, do I rectify, do I port my data, do I erase? Do I have automated decision making? What are my different aspects that I have as per data subject rights? And step 12 is important with respect to reporting breaches, and it will always happen. Whether you like it or not, there will always be data breaches. Your job is to have a mechanism for a data breach. Incident reporting and response and breach handling response and notification. Whom do you notify? Article 33 talks about notifying the supervisory authority. Article 34 talks about informing the data principal. How do I inform? Who do I inform? And last, in case I'm subcontracting, I need to have due diligence with my persons who I'm subcontracting to, my processor, and I need to have a contract management. So this was the entire roadmap of how I will do my GDPR implementation. And with that, I would like to throw the questions open for any of you to ask me questions with respect to GDPR. Thank you very much. And any questions that you may have with respect to GDPR or with respect to anything from privacy, I'm free to answer your questions. My apologies if it has been too fast. I like to take a little more time, but this is just a workshop. I generally urge people to come for my trainings, which takes 2 days, 1 day for PIMS and 1 day for GDPR. I go article by article, I read them through and take them through this. But hope it made justice. Hope you are able to understand this.
Thank you, Mr. Mukte, for your insightful and informative session on the overview of GDPR principles. We will now begin the Q&A session. Before taking any new questions, we will first go through some questions already shared by our participants in the Zoom chat box.
Sure. Regarding amendments to GDPR, is data encryption provided by databases adequate, or do we need additional layer of encryption at the application level? Well, I leave that to you to
The first
decide.
question is data encryption provided by databases adequate, or
Yes,
do we
I
need
that. I
an
think
additional layer of encryption at the
encryption.
application level?
It
So
depends
hope you
again
can
on the
understand the
criticality of the
question.
data. You can hear me, right?
Hello, sir.
Can you hear me?
Yeah.
Yeah, okay.
The first question is
Please.
regarding the new amendment to
Correct.
GDPR.
Correct.
Is data encryption provided by databases adequate, or do we need an additional layer of encryption at the application level?
You should do a DPIA, which is a data privacy impact assessment. Once you do a data privacy impact assessment, you will know what is the level of impact this particular piece has, and what tools you already have. If you feel that based on the impact assessment and the risk assessment, if the layer that you have is not sufficient, then you can add additional layer. If you feel that the layer that you already have is sufficient, because encryption provided at database level is quite happy. But there are two pieces you need to understand, guys. One is privacy by design, and second is privacy by default. Privacy by design is the amount of data, or should I say, the safeguards that you're putting till the data reaches your backend. For example, encryption, indexing, all this is happening at your database level till the time it reaches the database is called privacy by design. But when it comes to be shown to you, it's called privacy by default, which means if I want to see data, I see only 4 fields. If you see the data, you see 6 fields. My data till the backend is the same. Everyone, when they see the data at the backend, is the same. Only the data when it comes to the front end, when you want to see, is different. That is called privacy by default, which means I see data differently, you see data differently. So when I want to see, for example, I am just an end user. I can only see maybe 4 fields, and I see I cannot see your employee ID, or I cannot see your entire national ID. But you are an admin. You will be able to see 7 fields. So the extra layer that you're talking of may be applied when you are either an admin or when you have done a DPIA, a privacy impact assessment, and you find that the other people don't need, though it is encrypted at a time of transfer or at the time of seeing the data, which is privacy by default. If I want to see, that is again left to the data owner to decide if additional layers is required or not. All right, so that was the first question that I had. Second one talks about how can GDPR policies be implemented in the education sector, specifically for an international school. Now, if you're only talking about GDPR, then you have to find out if it is an international school as per 3 of 2, that is as per the territorial scope. Do you have any students who are from European Union? Only those people's DPI will need to be done, and you'll need to find out what are the level of security features that you have put in place. If you don't have anyone from Europe, then you don't need to implement GDPR. So if it is an international school, you have people who have come here, who are working with you, who are sitting in Sri Lanka, but there's no one from Europe, then you don't need. But if you have people in Europe, only those people's data will have to be additionally securitized, and you need to move. It's all about DPIA, guys. You have to do a data privacy impact assessment, find out how many people are involved in this part of this journey, and then fit it into that place. What kind of background checks and procedures should be followed during the implementation process? Is it with respect to question number 2, Janita? If that is so, what kind of background checks? Well, the background checks should be with respect to the people who are going to handle the data. Anyone who's handling sensitive data, it should be only restricted to read only, maybe, and that to only general data, that is PII, not SPII. Sensitive data should never be shown. You want to show someone his name and address. Nowadays, people are talking about geotagging. Even geotag is being used for privacy. People are talking about phone numbers also becoming sensitive, talking about emails being sensitive. You can decide what is the kind of background checks you want to do with respect to where they're coming from, what is the quality of the data, and do your background checks of the people. Anyone who's handling sensitive data, there is also something called a non-disclosure agreement, NDA clauses that you might want to specifically sign, and penalty can be done. I have seen places where people have added penalty clauses, and they have said in case any data gets lost, they can be held responsible. And we had a penalty with the processors. So we had a indemnity, we had a non-disclosure agreements signed with each one of them, and we had so those are the other checks that you can have. What are the most important first steps an organization should take to become GDPR compliant? I showed you a roadmap. Please use the roadmap. Make sure that you have a scope. Make sure that you have all your policies, process, procedures, all those entire roadmap. If you can look at, Make sure that you're completing it, and there is no certification, there's only compliance. So look at your data subject rights, look at your implementation guidelines, look at your documentation, go through your articles, see which articles are applicable to you. Out of 99 articles, not all of them are applicable to you. If you don't have transfers, the entire 44 to 49 will not be applicable to you. So first, make sure that you get your context. What are you doing? What scope do you have with respect to territorial scope from aspect to Article 3? How many of these articles are applicable to you? Whether you have processors or you're only controller. Once you know that, you know which of these articles are applicable to you. Based on this, do a DPI and then do your documentation, run it for 3 months, then do a audit, and then you'll know that you're compliant. So it is always good to get to know the scope, and only after the scope should you get your prior the documentations ready, and whether you need a DPO or DPL, and get your rights of the data subjects. So that entire 11 actives, the thing that I did, all those should be applicable to you. What tools are most relevant for protecting our data? Well, it depends on tools. There are a lot of database tools that you can use. You can do VAPTs, you can do encryptions, you can do pseudonymizations. There are different tools that you may use, again, depending on the amount of money that you have with you. So there's something called PET, which is privacy enhancing tools. Please have a look. The shortage of time, I can't tell you now, but there are a lot of tools that you can read, and again, based on the amount of money that you have to offer. So there are encryptions, there are anonymizations, there are hashings, there are a lot of tokenizations. So there are multiple methods that you can use when you are going into this area. How does GDPR contribute to the protection of personal data? In India or in Sri Lanka, it may be of no use. But by implementing it, it gives you awareness, contribute to the protection of personal data. Why is it important for organizations to comply to ensure compliance with these principles? Absolutely, because your awareness becomes higher. Today, if you go to a supermarket and give your phone number, you don't know where all it can get used up and who all can start calling you and misusing you. I came to Sri Lanka and came to a couple of offices. You guys are capturing national IDs in your registers. I come in and I look at your national ID. You know what I can do with your national ID. Is it really required? I went to an office in in Kuwait. They gave me a visa. Is it really required? Do I really need to see my visa and passport numbers? So it is all about awareness, and check whether the more aware you are, the see, we don't say that your data can never get leaked, but it is just that the more secure you are, the more ready you are, the lesser are your chances of getting lost, and the lesser are your chances of damage. Today, I don't have my data are masked. I have a RFID on my purse. So my RFID makes sure that no one can scan my data. So it's all about readiness and all about how well you are prepared for it. The more you read it, the better you will be. How can we correlate GDPR with DPDP Act? I did that last month. I think I can share that with you. Dharani ma'am, I think you have my deck from last time, right?
Yes, sir.
Yeah, if you can share that with them, I think there was some amount of correlation between DPDA and GDPR, which was given to them. So I think you can have a look. How can small and medium-sized organizations practically implement the requirements with limited resources? Well, like I mentioned again, you'll have to do a context. Based on the context, you'll have to see what are the requirements that you have. My suggestion is limit the number of people having access to personal data. The moment you restrict the number of people having personal data, automatically it will help you in limiting your scope of leakage. Today, you have limited resources, you have no tools. Yes, you don't have tools. Limit the number of people having access, limit the amount of people who can have send out data. Today, if I don't have I don't have emails, I cannot send emails out. I was doing an audit for a payroll company. They are not allowed to send data. Only 2 people in the entire company have access to payrolls. So when you stop external access, you limit the number of people who have access to personal data. You get them to sign the data. Ask them to sign penalty clauses. These are things which don't require money. These are things which can automatically be done. And constantly review. Have checks and balances put in place. And even those two people who have access, please check them out every time. Look at the data that they're sending out. That's the only way you can do with the amount of limited resources, guys. However small or big it is, train, and that's all you can do. How does GDPR apply to organizations outside EU that handle EU data? Well, it does. It is as per the Article 3 of 2, which I mentioned a little earlier. If you are processing data outside EU of an EU citizen, it applies to you. I showed this to you a little earlier in the article in my deck, and also as per Article 3 of 2. This is the one which I was talking about. The regulation applies to the processing of personal data of data subjects in the EU by a controller or processor not established in the EU offering goods and services. So your 3 of 2, this is what is applicable to you when you are part of that journey. And so does it apply? It applies as per 3 of 2, where you are outside the EU and you're handling EU data. What are the best practices for managing and reporting data breaches under GDPR? Well, the way for managing GDPR is you have to notify, and you have to keep tracking it. The moment you get a data privacy notice, immediately notify your supervisory authority, keep a track and see where did it happen, put a root cause, and then take it from there. Did it happen because of training issue? Did it happen because of access issues? Did a breach happen because of technical controls not put in place? I did not encrypt my data. And a lot of times people make the mistake of sending sensitive data in an unencrypted format. Even if you don't do it, at least password lock it when you're sending sensitive data. I have seen a lot of places people send out the Excel file in the same manner. If you don't have an encryption, at least password lock it. Otherwise, encrypt your data. Second, if you have data breach, immediately after data breach, first stop the place from where it happened. Second, do a root cause, find out where it happened, train everyone, keep a tracker, and make sure that it doesn't happen again. So it is all about reporting and managing and learning from controls. In information security, there's something called AF 5.24. And this is something I always try and suggest people, please, in your information security space, please invoke and do a data breach scenario. Always important. You do a lot of breaches with respect to tailgating, with respect to access rights, etc. Always also do one with data breach. Find out what will happen when you steal someone's personal data. How do you react? Train and move forward. It's all about your best practices are train people, train, make sure that it is with restricted number of people. If you have a data breach, do a root cause, find out why did it happen, make sure you plug that hole, train them, and then move forward and make sure it doesn't happen again. So it's all about, at the end of the day, it happens. If someone collects personal data without consent, but never actually uses it, still considered a violation? Absolutely. But it's all about getting to know. If you don't know about it, then you'll not know. But if you have collected someone's data, first is check the purpose limitation. Has it reached the purpose limitation? Collected data, but it has not been used for 2 years, 3 years, it's no longer valid. But use is what, madam? Please see the processing. When I spoke about processing in the morning, even if you're holding data, it is processing. So it's all about, end of the day, if any of these areas are being used, you're still using it. So you can't come and say that it is not being used. Even if you're collecting your data, it is under processing, which was there in the beginning. So you will still come under the aspect of collection. So it is under GDPR laws. You could still be under Article 3, you could be penalized. All right, any other questions? I hope I was able to answer all of them.
Once again, thank you, Mr. Muktesh. Hope all your questions have been clarified. So
There's one more question I think Tilana had. Is it possible to use data for R&D and learning purpose? No. You'll have to pseudonymize it. You can't use active data. Please pseudonymize it, change the name from me to call it user123 and use the data. I'm sorry, there's someone who's separately asking. Please put it in the actual chat, guys. It becomes difficult. Others don't know what questions you're asking. If you can look at it, I think they're personally reaching out to me. Please ask them to directly write. Is it possible to use data for R&D? No, please don't use it for AI unless consent is given. If you have got a consent, then yes, you can do that. How can data leakage be monitored and controlled when provided data to AI, and how does this align with GDPR? Well, you'll have to go and look at the learning data, your AI, and see whether that's where automated decision making is coming in. So you'll have to do an impact assessment, and in an AI, there's also something called system impact assessment. You'll have to do both and find out what is the impact that it does to the system, and you need to inform. And if no consent is taken, you shouldn't be allowed. So without consent, please don't do any processing of data. All right, I'm sorry, ma'am. I went over by 3 minutes. My apologies. Someone had another question. Yeah. Ma'am, please go back, ma'am. Please go ahead. Dharani, ma'am.
thank you, Mr. Muktesh. So we truly appreciate the knowledge and experience you have shared with us today. It was a very valuable session for all the participants joining from different industry. I want to express my sincere gratitude to Mr. Muktesh for his insightful and comprehensive session on overview of GDPR principles, and your massive knowledge and expertise provided valuable insights for participants across the industries. Thank you, sir, for your invaluable contribution and commitment. So, I would like to thank all who actively participated by asking insightful questions, and your curiosity and contributions are truly appreciated. Thank you again for making this session more meaningful. As we draw close to the end of this online training session, I would like to express my sincere gratitude to all respectable attendees for your active participation and valuable contribution for making this webinar a vibrant pool of knowledge and exchange. Kindly take a moment to share your thoughts and insights by filling out the feedback form now. So we appreciate your time and contribution to our ongoing commitment to excellence. Now the time is yours. Now you can fill out the feedback form which now appears in the Zoom chat box. Please remind, only those who have submitted the feedback form will be eligible for each certificates. So please kindly give your feedbacks by filling out the feedback form.
Dharani, ma'am, Muktesh here. I can drop out, right?
Wait, sir, we have to take a screenshot.
Oh, okay, fine.
Okay, thank you so much for taking the time to share your valuable feedback with us. We look forward to having you in our future sessions and continue this journey together with you. Before we wrap up, we would like to capture this moment. So now we request you to turn on your cameras and join with us to make this session more memorable. So I will take the screenshot after the countdown. Please be ready. So please turn on your cameras. Okay, 1, 2, 3. Thank you. I would like to express my gratitude to our resource person, Mr. Muktesh, and all our participants for helping us making this session a success. Thank you and have a good day.